Hey everyone, I want to make you guys aware of a gun case that is currently being heard before the Supreme Court. It's commonly referred to as the Rahimi case. Okay, so I think that this is a bad case for us. I'm not very optimistic about it. The general idea here is with this case is that there was a person with a restraining order who had a history of doing bad things, okay, but had no convictions. And what happened is some woman got a restraining order against him. With a restraining order, by federal law, you're not supposed to be able to. You're not supposed to have possession of guns. And this person was caught in possession of a gun while under restraining order. So it went to the lower courts, and the lower courts basically said not guilty, referencing text history and tradition of the Bruin case, which basically says there's no history that, where people without convictions who merely have a restraining order against them, there's no history going back to the founding of this country where those people would be disarmed. Okay, so the lower court said unconstitutional. Merrick Garland, okay, piece of shit, okay, rushed this to the Supreme Court, almost forcing them to take it, knowing that this was a case that would not sit comfortable with a lot of even the conservative justices, okay? And I'm specifically thinking about Roberts and Amy Barrett, because this person with this restraining order, even though he didn't have a conviction, basically there's a history of this person being bad and doing bad things and being violent and that kind of stuff. So no convictions, but there's definitely that history there. So this is the kind of person that is, I think, there's a good chance that he's going to scare the justices, specifically Barrett and Roberts, to basically cutting back on the methodology of the Bruin decision. Okay, so we know that the Democrat appointed justices, we know, that's a foregone conclusion how they're going to vote on this. It really comes down to Roberts, Barrett, and I don't even trust any of the other. The only one I trust on the Supreme Court is Clarence Thomas. I think all the others, I mean, it could be like an 8-1 decision against us, right? Everybody going against. And just to put this into perspective, there's lots of gun owners out there. There's lots of gun owners that I have heard say that this person with, a clear history of violence, even though there's no convictions, this is a person that people will say that they don't want to have guns. Even gun owners will say that they don't want this person to have guns, okay? And the problem here is that if the Supreme Court comes out in favor of Merrick Garland and the Justice Department, right, what they're doing is they're weakening the NYSERPA versus Bruin decision, right? Because NYSERPA versus Bruin, we have a very clear-cut methodology, text history, tradition. If the gun control law did not exist at the time of the founding, or basically when the Second Amendment was ratified around, it was 1791. If that gun control law did not exist at that time and was not widely enforced, it is unconstitutional. So Merrick Garland specifically picked this case because they knew that this guy Rahimi would seem scary, or very likely would seem scary to a lot of the Supreme Court justices. He's the kind of guy that would seem scary to even Republican conservative soccer moms. He's the kind of guy that seems scary to them, and I can see them going along with, hey, we need to find ways to take away this person's ability to own guns. Okay, so this is why Merrick Garland specifically picked this case and rushed it before the Supreme Court. He's specifically looking for a way to cut back the Bruin decision, which is the effect that this would have. It would give an exception, because right now we have the Bruin methodology of text history and tradition without exception. Okay, so if the Supreme Court rules against us, What they would be doing is introducing exceptions, okay? And then once you open up that can of worms of exceptions, you know, Democrats, anti-gunners are going to jump right into it and, you know, try to get as much out of those exceptions and try to draw them out and apply it to as many different things as possible. So that's what the Democrats are looking for here. They're looking to introduce exceptions into the Bruin methodology. Okay? Now, me personally, my personal opinion is, if you're safe enough to be out on the street, you're safe enough to own guns. If somebody is so bad that they shouldn't have guns, get them convicted, you know, and get them locked up. Okay, you know, that's pretty cut and dry. If somebody is safe enough to be out on the street, they're safe enough to own guns, because anything can be turned into a weapon. I can take one of these flower pots here and use them as a weapon. You take that hose back there, use it to strangle somebody. You know, anything here can be used as a weapon. There's some pipes back there. I can use those to kill people. So the point is, if you're safe enough to be on the street, you're safe enough to own guns. So I invite you guys to follow this case. I recommend the Four Boxes Diner. The guy is a legal scholar. Hold on, let me pause. There's an airplane coming in my head. So as I was saying, I invite you guys to follow this case at the Four Boxes Diner. I think the guy over there, I think Mark Smith, legal scholar, I think he's the best in the business, okay? And this guy is like cut and dry. He doesn't try to blow smoke up people's asses. He's not one of these feel-good gun channels, because that's one of the things I do not do. I mean, I don't like to create you know, a false impression of victory where there is no victory. Okay, so this guy's cut and dry, tells it like it is, doesn't try to just make you feel good. So that's the place to go get your legal gun analysis. The Four Boxes Diner channel. Okay, so this case over here, that's in front of the Supreme Court. It cannot help us. It can only hurt us. Okay, the best thing that can possibly come out of this case is it ends up on Clarence Thomas's hands. Okay, again, he would have to get 5 out of the 9 justices to go along with it. And the best thing that I think can come out of this is that they basically say that nope, text history and tradition still applies. If this guy is really that bad, get him convicted, get him locked up, and in the meantime, you have other options like basically keeping him in jail, you know, keeping him in jail instead of letting him loose. You know, there's because that's an option that the courts have. They don't have to set people free on bail if they feel that they are so dangerous. All right, that's another option. So they don't have to go straight to disarm option. There's other options if they feel that this person is dangerous, to keep the rest of society safe. Okay? So anyway, the best thing that can possibly come out of this is the text history and tradition of the NYSERPA versus Bruin decision is preserved. Okay, so again, we're not winning anything, we're not gaining anything. It's just preserved. But what I think is more likely to happen, because of the bad facts of this case, because this guy is such a, apparently he's a scary person, it is more likely that they cut back, you know, they introduce exceptions to the NYSERPA methodology. So definitely think you guys should follow it. So thanks for watching. I'll talk to you all soon.